Oklahoma Court of Criminal Appeals has abandoned the Chapman precedent for the plain error analysis on unpreserved constitutional claims, thereby shifting the burden from the state to the defendant. I'm Tulsa Attorney James Wirth, and that is the topic that we are discussing. It comes from a case from the Oklahoma Court of Criminal Appeals. It's Dominic Washington v. State of Oklahoma, 2023 OCCA 22, and it's a bit detailed. So it's a complicated issue, but I want to kind of walk through it here. So ultimately, we have a defendant, that's a Dominic Washington, charged with a first-degree murder, goes to trial, and at trial, the medical examiner's report, even though it contains hearsay, is admitted into the record, and even though that report also contains the analysis of the toxicology report, that's admitted into evidence, even though the person that completed that toxicology report does not testify. So there's a claim that it should not have been admitted because it's hearsay, and also that particular toxicology report should not be entered, one, because it's hearsay, and two, because it denied the defendant the right confrontation under the Sixth Amendment, because they didn't have a witness that could be cross-examined related to that. However, there was no objection at the time of trial. So when it came up on appeal, they made a note that it was unfair, violated his constitutional rights through the confrontation clause by admitting that toxicology report. And historically, the court has applied the Chapman precedent to that. We'll go over it. That's what we call, it's because it is not objected to, it's waived all but for plain error. So the question becomes whether it is plain error, and we'll go over the test for that. So in determining plain error, the court has 3 points they go through. One, the existence of an actual error. In this case, they determined it was an actual error, that it should not have come in, both hearsay violation and confrontation clause violation. Two, the error was plain and obvious. That means that this is not a novel decision that needs to be made, but there's prior precedent that makes it clear, prior law that makes it clear that this is not admissible. And they find that that is the case here as well. Confrontation, lots of case law on that. It's well defined. It's been applied in other cases specifically to these types of reports, so it should have been known. So those are the first two steps. But then we get to the third one, and that's what's in controversy here, that the error affected the defendant's substantial rights, meaning the error affected the outcome of the proceeding. So historically, the Oklahoma Court of Criminal Appeals has always used the Chapman test from the United States Supreme Court, and that puts the burden on the state, on the prosecutor, to prove beyond a reasonable doubt that the error was harmless, i.e. that it made no difference in the effect. Because the court's already acknowledging here, yes, this trial wasn't exactly fair because his constitutional rights were violated. The court has already found that. His constitutional rights were violated. He was denied the opportunity to confront witnesses. But now is the court going to provide any relief? And under the Chapman precedent, it allows the prosecution, in this case the state, to prove beyond a reasonable doubt that the error, that the violation of the rights was harmless because it doesn't affect the outcome. But let's see what they actually end up saying here, because that's the test they've historically done based on that United States Supreme Court precedent. But here on page 8, it says, in determining the impact or prejudice of this constitutional violation, the state asks us to reconsider our precedent of applying Chapman harmless error to unpreserved constitutional errors. And they request that the burden should be on the defendant to prove that the error wasn't harmless. So it's a shift of the burden from the prosecution to the defendant. It notes that following Flores, a different case, this court has routinely applied Chapman harmless error to unpreserved constitutional errors on direct appeal and supplanted the showing of precedent by the appellant. Okay, and it talks about unpreserved constitutional errors. What that means is the defendant or the defendant's attorney did not object. So these are errors that occurred, that we know that they occurred, but they weren't objected to at trial. And the state's saying because it wasn't objected to at trial, the state shouldn't have the burden to prove that the error was harmless. The burden should shift to the defendant. In Chapman, the United States Supreme Court held that a preserved claim of constitutional error identified on direct appeal does not require reversal of a conviction if the prosecution can establish the error was harmless beyond a reasonable doubt. So they're trying to say that this precedent should only apply to preserved claims. Conversely, unpreserved constitutional errors are only subject to plain error review where the appellant bears the burden of demonstrating prejudice. And this is ultimately the finding. Upon renewed consideration, we find Chapman harmless error should no longer be used when reviewing an unpreserved constitutional error. So the court has acknowledged that the defendant's rights were violated, that specifically constitutional right to confrontation, acknowledged that that was violated, acknowledged that it always previously followed the precedent in Chapman, which puts the burden on the state to prove beyond a reasonable doubt that it didn't affect the outcome. But yet it is deciding, pursuant to the request of the state, to throw that test out, shift the burden to the defendant, where the defendant, who we already know his rights have been violated, now he has to prove prejudice that it would have affected the outcome. So that's the decision that we have here. The moral of the story is that we have a continued moving of the goal line by the Oklahoma Court of Criminal Appeals. They're changing the rules. It's been pretty consistent over the last number of years. They're doing so in favor of prosecution, in favor of the state, and against defendants. And in this case, the other thing that you need to know is obviously this is happened because the error was not preserved. It was not objected to at trial. So what occurs at trial is important. Who's representing you at trial is important. You want to make sure that you verbalize all of those objections on the record so they're preserved for appeal. If you're dealing with a criminal case, this can be complicated stuff. You're going to want to talk to an attorney privately and confidentially about that. To speak with an attorney at my office, you can go online to makelawEasy.com.